So I'm Paul Gangsey. I'm the Executive Director of Brooklyn Law School's Center for Urban Business Entrepreneurship, and I'm very glad to add my welcome to all of you for being here for this session. I just want to say a couple words about CUBE since it's a new venture here at the law school, and we want to make sure everybody knows what we're doing. CUBE was launched last November, and it's very quickly become a hub in Brooklyn for the study and consideration of the issues and practices that affect the amazing entrepreneurial community that's all around us. And also for events like this where we get an opportunity to bring together students, alumni, faculty, and both scholars and business people from the community. CUBE has two major goals. One is to train and enable our law students to work with new businesses and entrepreneurs in actual consultation and advice, and train law students to become the kind of lawyers who entrepreneurs welcome rather than run from. And we do this through scholarship, through practical experience in clinics and externships, and through public policy analysis. We're working right now with a couple of different city agencies doing white papers addressing issues that they've referred to the school and to CUBE. CUBE's a new venture itself, but it's built here at the law school on a whole variety of terrific programs and activities, and one of those is the Trade Secrets Institute under Professor Beecham's direction. So we're very pleased to be a co-sponsor of this event and are looking forward to this afternoon's panel. Thanks very much for being here.
Hi, Dia Liu here. Going to briefly introduce the panel. Today we have Jeffrey Schwab, partner at Abelman, Frayne & Schwab, Mina Kaplan, counsel at Paul Weiss, and Amit Eckstein, counsel at Moses & Senior. So can you give us a brief summary of your practice and how it relates to trade secrets?
First, as an introduction, I am a graduate of the school. As a matter of fact, Dick Farrell and I were in the same class, which I ask you now not to do the math on that. I will also say that my son has been active in CUBE as well. He is a partner in the firm. I'm a patent attorney. Our firm is exclusively directed to intellectual property rights. For the most part, much of our clientele are major Fortune 100 companies who we represent both in the United States and around the world. Nonetheless, recognizing what reality is, we have created what we call a startup group. Technically, I'm the head of it because I named it, but the real workers are those who really do the labor. And what we tried to do was to create an environment where our attorneys reach out into startup organizations and provide counseling on intellectual property rights for first, frankly, the first interview for nothing, and then at significantly reduced rates. We believe that is the future in this country. We believe as well, from enlightened self-interest, it is the future of intellectual property law, and in some ways, the firm I helped create. We have about 100 people at the firm, so we do have the ability to put these efforts forward, and we believe and hope that we can provide meaningful direction.
Thanks. My name is Mina Kaplan. I am counsel at Paul Weiss, Rifkin, Warren, Garrison here in New York City, which is a fairly large, typical large New York City firm. We have a very large corporate practice. and I work in the corporate department. You know, I think the question is kind of like how my practice relates to trade secrets. Typically, Paul Weiss is involved in the startup market more on the acquisition side. We find ourselves more frequently representing the acquirers of startups, entities, venture capitalists, private equity, and other funds investing in startups. And in these transactions, it typically takes a number of different constituents within the firm to actively represent our client. You have the typical M&A and corporate side dealing with the nuts and bolts of the acquisition, but also dealing with understanding the technology, understanding how protectable that technology is, and valuation. That's where more specialized expertise and my background as a software developer sort of lends itself a little bit more to that, and I find myself working in that area. We also do less frequently represent startups. We're involved in a number of startup endeavors like Cube, and it's really great to see and work with not exclusively young people, but more frequently young than not, you know, with some really great ideas and really pushing the envelope on what's technically possible and bringing some very cool things into fruition.
Hi, my name is Amit Eckstein. I am counsel at Moses & Singer. Moses & Singer is a mid-sized law firm, maybe somewhere between the two shops that they work at. We are a New York City-based firm. My practice is a technology-based practice. I work in IP technology and privacy, and I typically advise on transactions where we're exploiting IP or somehow acquiring it. Software licenses, development agreements, apps, that kind of thing. The terms of use that you click and don't read, or privacy policies. I spend a lot of my time writing those. And then advising on what a privacy policy really means, and how the firm has an initiative with a lot of life sciences companies here in the city, startups and scientists that, and so we advise them similar to what Jeffrey was describing, you know, early cycle kind of advice to help them come to market and really on a almost pro bono basis, you know, bring their products to fruition.
Okay, so let's start off with why is it important for startups in general to protect trade secrets?
Well, I can answer that, but I think the better way to begin it is to explain how trade secrets have almost become a stepchild in intellectual property to now something that people have to really be consider. You come to me and you say, I have this greatest, wonderful new idea, it's a new business, and it's embodied in this great software program that I have developed. I want to take it to the next stage. I want to bring people on board. I want to monetize it. And everybody wants to be the next Google, but most people even have sites lower than that. They'll take $100 million. They don't have to be a billionaire. And they say to me, how can I best protect myself? And they say, I've heard of patents, but I'm not really sure what they're about. I've heard of copyrights. I'm not really sure exactly what I get. I've heard of trademarks, and I think I know, and I heard of trade secrets, and what should I be doing? Patents protect inventions. They are the physical embodiments, and what they provide is a trade-off. Tell the public something it didn't know before, teach them so that we can all learn from that technology, and both use it during the pendency to improve it, and after the patent expires, there's a blueprint right there. I can make this product. That term is 20 years, and it is a wonderful thing to get if you can get it. Copyrights protect literary expressions. A book, software, but they don't protect the idea. Moreover, nor does a patent protect the idea. It protects an embodiment of that idea. There are people that can design around it. Trademarks protect your name, your goodwill, who you are, Coca-Cola being one of the more famous ones. What are trade secrets? Trade secrets were defined by the prior panel, who, by the way, was superb, as anything really that is useful in your business, is not easily reproduced, and is protected in a manner that makes it special. So if somebody said, did you really consider it a trade secret? The answer is not only I considered it, I protected it that way. Now, one time, I was a big proponent that if it was patentable, that's the way you got to go. Why? A lot of reasons. First, I'd rather have the monopoly and have a trade secret which gets lost if it gets disclosed. To have a trade secret because it has a life only as long as it's secrecy. Secondly, I have found, and I tell young people in particular, investors love patents. When they get a prospectus and look at it, they say, gee whiz, you're going to have exclusivity. I can touch it, I can feel it, I can see the document, I see the seal of the US government on it. We have a weapon, we have an asset. The problem that has arisen most recently, and it really is since June, is that the Supreme Court of the United States, in a case called CLS versus Alice, determined that a business methodology claimed as a method of doing A, B, C, and D actually to protect a hedge, and which frankly was pretty novel, was not patentable because, not because it wasn't novel, not because it wasn't useful, not because it wasn't obvious, because it did not qualify as patentable subject matter under the Section 101 of the patent statute. What does that mean? Well, they said we are not invalidating all software patents, and we're not saying software cannot be patented. But they then tried to define what software might be patented. And as a patent attorney, a litigator, and a counselor, I can tell you that my brethren and I have no idea, and will not have any idea for the next couple of years, where the line is drawn. The Supreme Court didn't draw it correctly, or they didn't draw it explicitly. They drew it in ephemeral terms. If you come up with something new, and the only thing that connects it to a machine is it's something that can be worked through a computer, and it's a general purpose computer, that's not patentable. If on the other hand, you make the computer more efficient, that would be patentable. Okay, what does that mean? Well, if I have data compression and I can't show enough pictures because I don't have enough memory, so I have an idea and I just show less of the picture so I can fit it all in, probably not patentable. If on the other hand, I come up with something that makes that a more efficient computer, is patentable. What it did is a couple of things. According to some statistics I have seen, there's been a 40% drop in patent litigation. People are not trying to even enforce their software patents. Secondly, under the new Patent Act, there's this IPR, inter-parties review, that permits you to go back to the patent office, both on business method patents and on any kind of patent, and there's one filed every day. Now I think there's 2,000 files since the 2.5 years that you can do it. Patents are being challenged, and patents that issued on software are now suspect. So what do you do? Why should you now think about protection? You now must, in my judgment, come forward with a unique way of looking at the world. One, start by taking everything that you think could be a trade secret and properly protect it. Second, what we have been counseling some of our people to do is file a provisional patent application on what you think might pass muster as both a patented device that would pass muster. If you file a provisional application, it doesn't get examined, it's not public, nobody gets to read it, nobody gets to see it, you have a year. When that year is over, you can abandon it, or you can file a utility application, which that won't be published for another 6 months because you have 18 months before publication. Keep it secret. And let us all sit together while that is happening and watch the law develop. And in a year from now, or 18 months from now, if it looks like what you have cannot be protected by a patent, stay the trade secret clause. You have another benefit. AIA, the new Patent Act, there's a tendency among patent attorneys and lawyers to use these acronyms that they think when they say these words, everybody knows what they're talking about. It's a brand new Patent Act in this country. And we're all learning to live with what that says. They have a special provision that we didn't have before. One of the problems you had, if I told you to keep something as a trade secret, and it technically was patentable, but you didn't patent it, somebody now comes along and they patent it. And they can do that because, as far as the public knows, what they did was novel, unobvious, and useful because you didn't disclose it, so the public didn't have possession of it. Now they sue you for the use of something that you had a prior right, a prior use right in. So there was a significant risk in trade secrets. The downside being, you can get sued if somebody patents your trade secret from under you. AIA has a prior use right. AIA prize is protected. If you can show that, in fact, you had that use before the filing, you have a protected right. So what do I say now? Why? If you're an entrepreneur, you need to get protection. If you don't, you won't get investors. You won't be able to monetize. My suggestion is trade secrets are now going to be significantly more important to you, and they have to be part of the package that you want to analyze and look at. And there are strategies to combine trade secret protection, or at least the maintenance of that protection and how we do it, and we'll get into that in later discussion here, and an ongoing policy so that you can get the money you need to make your dream come true, if in fact it can be made to come true. And it has the essential benefit of not having to be filed with any government, not having to be paid substantial fees to write a patent application costs $10,000, $15,000 just to draft. Trademark application, a few $1,000s. Copyright's less expensive, it's in the hundreds of dollars, but it doesn't protect the idea, and you should use that as well. Trade secret's nothing in terms of immediate outlay, if you do the paperwork and get the understanding of what is needed to maintain it as a trade secret. The burden goes to you, and we'll get into it later on how you do that. So a very long answer to a very short question. Trade secrets have gone in the last year from orphan technology and the last thing the patent attorney thinks of to shame on you if you don't think of it first.
I mean, I'll just tee off a little bit what you said, Jeff, at the end. Trade secrets, you know, the question in terms of the difference between trade secrets and patents and copyrights and trademarks to a certain extent is really the cost from a start. I mean, there's many differences, but one difference to focus on is really the cost in obtaining that protection. You don't need really any significant outside cost in terms of legal fees, filing fees, and preparation fees and whatnot. You know, you really need an NDA. You need, one of the key elements is protection. You have to provide and show evidence if you are trying to enforce your trade secret that you've taken steps to protect that. And that's typically in what was called a non-disclosure agreement, you know, or confidentiality agreement, commonly known as, referred to as NDAs. And putting even a bare bones NDA in place, something that you jot out at the back of a napkin, you know, saying that I'm telling you this and condition that you don't disclose it, is evidence, if needed, of taking protections to protect your trade secret and providing you with trade secret rights. So when I'm talking to a inventor or to a startup, they're strapped for cash. And, you know, why throw money at a patent application which can cost you thousands and thousands of dollars where you have a trade secret protection?
So I'm going to kind of draw a landscape of just stuff that's on my desk that I just dropped jotted down and to give you an idea of what I'm looking at. In life sciences with patents, you have two different general things. You have someone that invents a compound or someone that discovers a process. That's a process that exists in nature. And a process that the Supreme Court has found, like a genome, can't be patented. So that's something that you would protect as a trade secret, whereas a compound you really would patent, with the idea that you have to, if you're going to do the filing, you have a 20-year lifespan, there's FDA, and you're really killing the utility potentially if you can maintain the secrecy. So those two. And then a bank, and a bank has algorithms, let's say a trading platform, and they would have a way of, algorithmic trading is really big now in the news, of making trades at certain times to, capitalize on swings in the market. And then, an app platform, like literally like a, any app that you would download on your phone, and the idea that, really their kind of idea is to be the first in the market with a cool functionality, and they're not really disclosing it to anyone. They just want people to adopt it, and so they would hold on to it as a trade secret. And then the last would be kind of the flip side of, well, maybe not the flip side, but another type of app, which is a platform like a Red Hat. Someone that wants everyone to adopt their technology, and is really about opening it up, and it's almost the opposite of the trade secret, right? It's like just an open idea, and so they're not protecting that part at all. And so I think that depending on where you sit, it just really depends how you're going to protect it and what mechanism or combination of mechanisms you're going to use to protect what it is that you're seeking to protect.
So how do you evaluate trade secrets in transactions, for example, in a round of fundraising?
I think part of it is twofold. One, what is the trade secret? If you're asking me to evaluate something, is it an advertising strategy? Is it a bidding method? Is it a costing information? Is it a customer list? Is it a database? Is it an engineering drawing? Is it a formula in a notebook? It's a machinery process, a marketing strategy, negative research, payment terms that people are willing to pay, pricing information, production techniques, profit margins, promotional discounts, strategic plans, LinkedIn contacts, which have been held in proper circumstances to even be trade secrets. There are judges and there are judges, but look, it depends who's paying. But seriously, when you ask to evaluate, and that is, I think, a critical thing from our perspective, first what we ask our prospective client is, let us delineate what you know and consider presently a trade secret. Let us delineate what we will probably have when the friends and family money runs out and we have to go to for other people's money. Let us then do an evaluation. Regrettably, I think our accounting processes today don't really have a good handle on how to value trade secrets. And investors, I think, are simply as mystified. I mentioned this over lunch. Google's basic success is based on a specific algorithm, which they kept as a trade secret, on really how their search engine did its thing. If they had walked into our office and said, value it. Today, billions. Matter of fact, even if that trade secret is lost over time, they have so much lead time that even Microsoft with Bing doing the same thing can't compete with them. So you have to determine what the secret is in terms of valuing it. Then you have to be marketing smart. You have to be able to express that to someone that you want to give you money, to part with money for a valuation purpose. If my company is worth $100 and you want 10% of it, you're going to give me $10. You say, fine, where'd you get the $100 from? It's the same analogy when you're looking for money. What is your initial valuation? Well, what are you putting on the table? An idea. An idea which we think is unique. an idea which we might be able to file a provisional patent application for but keep secret. An idea, we've done that, and we've done some beta testing, and we got some results, and the people are wonderful with it, but they don't know how we're doing it, because they can't tell the secret sauce. They know what they started with, they know what they got, they don't know how we took them there. We've done an analysis. It will take at least 2 years to reverse engineer. By then, we'll either make it or lose it. $2.5 million. They can argue with me, say 5, they can argue with me, say 1, but it's not going to be $100. You are in the business. My biggest problem I often have with startups and inventors is they don't think in terms of business. They think in terms of the miracle that they have wrought and the vision that they see. And part of our job is to bring that down to earth, put together a business plan that values what you have in a meaningful way. And frankly, in the world of software, the patent is out there almost as a lead so that the investors really think maybe there is something there, but the trade secret's where the money is. And we just you have to find a way to fashion that. And so that's what we try and do. We also protect it through copyright, and if those people who are concerned that if you file a copyright, you're giving away your trade secrets, you're not. The Copyright Office is smarter than that. They permit you to file what's called a mask. You put your software in, you put a mask over it, so it's gibberish. If you take the mask off, if there's anybody sues, they say, how do we know that that's what your copyright really covers? You unmask. So, copyright's a few $100s. But again, it impresses investors, and besides which, it actually provides you with meaningful protection. Because somebody's going to have to go into a clean room and try and do it. So, I'm sorry again. I can't answer your question with a number, but I can answer your question with a formula.
To talk about evaluation, and I'll give just a very, myopic view that I see in the market. Over the past, I think throughout the previous internet, and focusing really on Silicon Valley, which is where a lot of my practice is, the 1999 and 2000 internet boom, there was a lot of generalization. There was a lot of investment cycles that were in investors chasing ideas. And I think in today's cycle, it's much more specialized. There's a lot more funds that are investing at early stage, and they're also a lot more experienced investment managers. So the question in terms of how do you value a trade secret, it's typically done in the context of the larger offering that the startup is bringing to the market. There isn't a secondaries market for trade secrets like there are for patents or for copyrights in a certain area. Publishers are always valuing copyrights, in terms of in movies and books and other works of art. There's a market for ascertaining that value. There's a market for acquiring patents. It less so in trade secrets. So my short answer is you value a trade secret based on the maybe not much, but the larger offering that's being made by the startup, if it's in a startup context. And there's a lot more expertise on the ground looking at how this can be brought to market, how this can be incorporated. We talked about Google. Google Ventures is really thoroughly staffed. They do a lot of early seed venture funding. They know how this can fold into a Google-like company and what value that can add. They're frequently wrong, but they have an idea of what they think, and I think that's how I see trade secrets being valued.
So I think it depends on what you're actually looking at. Let's just kind of use it in reverse. In bankruptcy, it's the sale value, right? So in the Barnes & Noble, when it purchased Borders' list of customers, that was their trade secret, and they put a number on it, and there was a whole fight over whether they could actually just purchase the customer list, and that was valued at several $1 million for a list of customers. In a transaction where you have let's say an app, and it's really maybe it's not the trade secret as much as it's the first mover. It's the idea to get this functionality out into the market. And we're going to be the first one with a cool name out there, and we know people are going to copy us, but we're going to take the first mover advantage. And so the trade secret, we're not going to seek the patent protection because this idea isn't going to last for 20 years. This isn't something that we need to protect for 20 years. And so we're going to keep it close for a short period of time and then go out into the market. And before someone figures out a way to reverse engineer this, we're going to already be the name associated with it. So I think you look at, the lifespan and what we talked about, how long it'll take for other folks to catch up with you and what kind of advantage. It's kind of the same point really, but in reverse, how long will it take other people to catch up to where you are? And those are different ways. I guess in life sciences, there's also just a totally different thing. It's, if you discover a compound or you discover a process, then you're dealing with big pharma, and then you can put your pinky in the corner of your mouth and start naming numbers.
So,
As a representative of some of Big Pharma, you and I should negotiate.
so how do you deal with balancing the secretive nature of protecting trade secrets with the culture of openness in the tech and startup world?
I think that's a very fair question and a fair point. And by my identifying where it went, how long ago I went to law school, I probably am going to take a more conservative approach. I truly believe that protection and intellectual properties, as distinguished from openness, is a better way to succeed. Indeed, it is expressed in our Constitution as to secure for authors and inventors limited rights in their writings and discoveries. And we have, there's very few commercial terms in the Constitution of the United States, but that is one of them. And that is that is the nature of our view of how to protect ourselves. In fact, I may be speaking out of school here, but you understand that part of the Revolutionary War was fought on the fact, or the commercial aspect, is that Americans went into the knitting mills in England, stole the trade secrets, brought them here, and created our economy. And in fact, the founders, I believe, understood that and believed that you need effective protection as a matter of law. So while we sit here today and we're looking at other countries as basically eating our lunch, history is a little bit of a teacher. That's kind of how we got our start. But going back, I think that there is a balance that actually occurs. There's a thing called FRAND. It's, if in fact you create something that becomes a standard, and a standard-setting organization adopts it as the standard, and therefore everybody builds from that standard, and you get a patent, you must license it. You must make that license available on reasonable terms. That is as part of the law. In fact, our federal government has tried to take issues with companies that have tried to circumvent that. So the answer is, I believe in the protection system. I believe in checks and balances to it. I believe there exist checks and balances already with regard to standard essential technology, and I have one vote.
I think, I mean, to take it a little bit differently, how do we deal with trade secrets, particularly the word secret, in an open economy, or, particularly in the startup area where you have a lot of sharing going on in software? I mean, I think the answer is they're not incompatible, right? A lot of the methods to which there's a big distinction when you're talking about software between what's source code and object code, right? Source code is what human beings or today even computers write in terms of setting up the program. That's then compiled and produces something called object code, which computers can read and create functions. In the sharing and open economy, you can share your object code very easily, and you can You mentioned Red Hat earlier. Red Hat is in the business of distributing an open source product, a product that the code is freely available on, and they're a public company and very successful at doing that. So there are ways to combine the proprietary nature of what one party is bringing to the table in an open environment. And some examples can be what you see now in a number of my clients. I won't talk about my clients. Amazon, Cisco, they're developing this very large cloud infrastructure to support applications. And part of their offering in this space is a set of routines that will do business logic. And you can rent space on the cloud. If you develop an app, it can have immediate effect to support millions of users simultaneously, because you're essentially hosting this on Amazon's infrastructure. But Amazon has provided for you a number of tools that they keep as trade secrets and they keep proprietary, and they're made available for you to integrate and run your application off of. So I really think that at a granular level, at where the rubber hits the road from an application perspective in my narrow sort of software tech space, those two things, although they sound incompatible, are in fact not, and one can really maintain value around a proprietary sauce to an offering that they're making globally available and encouraging others to use and interact with.
I think I'll take it from the employee perspective of educating your employees and explaining to them, this is, if you're going to go out and speak, this is what you should be speaking about, but don't discuss, this, and you kind of educate your staff about what they can actually discuss or what's off limits. And I would equate that almost to, a recipe book, right? You could, I don't know how many people have gotten recipes from someone, a dish you loved, and they gave you the recipe, and it just doesn't come out the same. And they didn't tell you that they heated it to 120, or they let the egg sit, or whatever it is. So, it's withholding certain critical pieces. And so you can have, in the developer world where folks come from a very, Larry Lessig open kind of world, where they want to share and everyone should kind of work together, those folks are very valuable and important and are really the innovators in a lot of ways. And part of their innovation is based on this collaborative approach. But, that's something that you have to balance when you're trying to maintain secrecy. So I think, educating your employees, coming up with a script of what, is off limits versus what is okay to speak about is kind of the way we handle it for technologists.
So should the founder of a company really make everyone he talks to sign a non-disclosure agreement? For example, how do you deal with pitching to a potential investor without an NDA?
Often uncomfortably. The speakers before us mentioned this, the speakers here have mentioned it. The key, and we can give you a checklist and some questions that will help put that checklist, put some flesh on the bones of that checklist on what you're supposed to do. I mean, obviously, when a company starts, it's small and everybody loves everybody, but unfortunately, that doesn't happen in the real world. As people split off, success doesn't come as quickly as you might want it, and people leave. So we have to protect it. But the fact is that many times you want to convince somebody to provide money to you. And you say I'd like, and then you sign an NDA. And then the NDA basically says as follows: I'm going to tell you something, promise me you won't tell anybody else. And the guy looks at you, or the woman looks at you and says, well, how do I know what you're telling me is something I don't know already? It's all right, I'll write an exclusion. If you can show me you knew it before, then we'll exclude that in the NDA. Okay? Suppose I pick up the New York Times tomorrow and there it is. I didn't know it, but it was disclosed by someone who had no obligation to you, didn't violate any rights. Are you going to restrict me from doing that? No, we'll put that in the agreement. Suppose a third party comes to me because I don't like your plan, and they come up with a very substantial plan that's very much similar to your plan, with similar ideas. Can I do business with them? The answer is, of course you can, as long as... So when you say they don't want to sign an NDA, you're not asking them to say blindly, I'm going to tell you something and promise me, swear to God, don't tell anybody about this, and then you tell them something they knew or you hurt them in their business. But what I try to tell them is, I will give you all of those exceptions, but you're not in my business. You're in the business of raising money and evaluating, okay? I am going to tease you. I am going to tell you maybe where the beginning is and where the end is, but not how to get there in the middle. We don't need an NDA for that because, frankly, the first time I put a beta test out or anything like that, people are going to see it anyway, so all I'm doing is anticipating. I want you to sign an NDA with a very limited window of time because I don't want to make a public disclosure. If I do that, I can blow my patent rights. I haven't got a patent application on file, so we can even put a time limit on it. The NDA is only good for a year, only good for 2 years. If none of that works, bite the bullet and make a hard decision. But if they're telling you that they won't sign at that point, I would go shopping first. I wouldn't readily make that deal because there is nothing they're telling me logically that suggests to me that they have any need to know this until they have come forward with a greater sense of, I'm with you on this. So in general, we resist to the greatest extent possible, not signing an NDA, but we are not inflexible in the language to meet the obligations, the needs, and the legitimate concerns of those people who we are negotiating with. And I have found from experience that most people are understanding. Because you turn around and say, look, you invest, if I give this to you now and I blow the trade secret and we become a big success, you cause the business to commit suicide. You're injuring your own investment. We have been relatively successful in presenting and having people sign off on those things.
I mean, again, you know, my market, the market I at least practice in is a little bit different than some of my colleagues. In the software and high-tech space, NDAs in certain markets are not common and not commonly used at all. For example, you know, Mucker Labs, Y Combinator, some of these really, you know, seed funding organizations deal with so many startups over the course of a year that an NDA is a potential liability if a startup doesn't go south, they pass on an investment round, they pass on a subsequent investment round, that they're not willing to take. So in early stage investing by professional investors, NDAs are not common. They typically won't sign them. And this tees back into what we discussed earlier. How do you have trade secrets in an open environment? And there are ways to maintain effective secrecy around your really secret sauce. I mean, don't forget that, you know, as Jeff said a minute ago, by the time you launch your application, a lot of what you're bringing to the market is going to be public anyway. So that's not really your trade secret. By defining internally with more, you know, more clarity as to what is in fact proprietary, your source code, et cetera, and defining policies around it, you can, you know, pitch your idea to investors without necessarily signing NDAs. That, you know, this isn't really sort of a practice guide. I mean, yeah, I think, you know, seek reputable counsel if you have a real idea and you want to see, you know, talk to investors. But as a general rule, they're beneficial, they're helpful, they're evidence of trying to maintain secrecy. They typically are highly negotiated with sophisticated investors to carve out a lot of the things that Jeff said. So they're not as common in some markets as you would expect.
Yeah, I think it depends on your space and your type of idea. I think that if you're going to an angel or some sort of VC, they get a lot of ideas and they don't want to sign at the first, you know, the first round. And you know, I think, you know, as far as being the advice to the person who has the idea, you should have a pitch around the idea. It doesn't give up your secret sauce. You should say, look, this is let's just use the algorithmic trading. I have a way to algorithmically trade that will give you these kind of results. And you talk about the results and not about the actual algorithm. And you're able to go, and then they say, oh, I'm really interested in that. Let me kick the tires on it, and that's round 2. And then that's when an NDA really becomes more valuable, especially in a VC world. You know, with a compound or a process, you know, it just depends on, you know, who you're going to. Again, they don't want, in the first instance, to sign an NDA. They want to understand, okay, that you have a cure for this kind of cancer. Well, that's, you know, that's not something that we're interested in. Or you have a molecule that does this. Okay, well, maybe we want to see some of the science there. And then an NDA, again, becomes more interesting. You know, one of the things that I think is crucial for someone with an idea in NDAs is that rather than going out and giving an NDA to everyone that you're pitching to, you should come up with a pitch that doesn't require you to hand out NDAs.
Yeah.
You know, because an NDA in a lot of ways, you know, and litigators will take offense to this. A lot of ways they're a speed bump, and if it's in the Times, the damage is done, and then you're no longer pursuing the business of whatever you had invented. You're now litigating over this lost idea and what the value is. So it's much better to protect it and only give up so much information as you need to kind of pique the interest and then narrow down the people you're actually sharing the idea with.
If I can just comment a little about that. I agree with, frankly, with everything that my co-panelists have said. But that history was written at a time when most of the time, if it really was software, somebody had filed a provisional patent application before they had the discussion. And so they felt significantly more comfortable with being a little bit more open with the disclosure on the basis that the trade secret might be important, but the patent might be the thing that's going to carry the day. I think we have to take a kind of a fresh look at that, given that Alice CLS case. I think that that's why we generally counsel to at least try and create a patent application that we think in today's world would withstand the smell test, and at least try and do that so that you're really not naked out there with a potential investor, or indeed with your co-venturers. So again, I accept that yes, the custom and usage was that you know, you would try and get them as much information that you knew you were going to end up losing anyway pretty quickly, and just keep the secret sauce yourself, but you still push for the NDA. But most of the time you back that with at least a provisional, some kind of, quote, software patent application as a backstop. It's going to be a lot, I think the world's changing on that. I think it's going to be a much more difficult sell. And I think that it's going to present challenges to startups as well, and as well as the funders. Because when you say to them, look, if I know you don't want to be swamped with all this, I know you don't want to be precluded from talking to other people, I don't want an invitation that this document becomes, as you say, the basis of a complaint. Your idea is not taken up, somebody comes up with something sufficiently close that the next thing you know, you've got a lawsuit that you somehow breached my confidentiality. But this is, we're in a changing world, and I think we're going to have to make some adaptations, and I don't think there are any absolute clean answers to it right now.
What's really funny is when you're talking about investment rounds, you typically will pitch to a number of investors simultaneously. And all, you know, investors will say, oh, well, I'm not going to sign an NDA. As soon as an investor participates in an A round, and you go to a B round, they want everybody to sign NDAs. So, you know, it really, you know, everything we say here, like, is you know, we're looking at things, you know, dancing on a pin of a needle. Things change rapidly, you know, and depending on one's interests. And you know, as soon as you have a vested interest in the entity, your views change very quickly.
So as an employer, how do you hire employees who are experts in a particular field while also shielding your company's work environment from being infected by that employee's previous employer's IP?
Well, there's no perfect answer because basically you're accepting somebody's representation and word. If you hire somebody from a direct competitor, you can expect a letter that basically says, look, and we're not going to get into this anticipatory issue of, I have it in my mind and I can't erase it, because you may get that back in those states where I have it in my mind and you can't erase it. But that's not the majority rule as that was discussed earlier in the panel discussion. What you try and do is, one, get them to sign an employment agreement. Two, that could have many terms about, and frankly, if you're going to get a transfer of intellectual property rights, et cetera, there's got to be legal consideration for it. So if you don't do it at the beginning and you just say to the guy 6 months later, gee, I forgot to sign this, there's been case law that says that's not an enforceable contract because there's no consideration for it because he was an employee at will. But you put a contract together, or terms, it doesn't have to be that fancy, and you say, look, I'm hiring you. You are make definitive representations. It is a policy of this company not to trade on trade secrets or intellectual property rights of third parties, including your former employer. In some instances, it's usually a salesperson and it's a customer list. You are going to represent to me you haven't taken a customer list. You're going to represent to me that you've not taken any computer, you've not downloaded into the cloud, and you make those representations. Now, that doesn't mean you're not going to get a cease and desist letter, or at least a letter making an inquiry from the former employer, particularly if they felt, and particularly in sales. This is a very sensitive situation in sales because these salesmen have, I can post all over the world that I do business with General Motors. And so you say it's not a secret. But the secret is who in General Motors makes the decision about tire purchases, and who is his boss, and what is their budgets, and when is their sales cycles. Those are the kinds of things, but much of that is just portable. This is your ordinary, this is what you'll learn in the business. But in any event, to get back to what you do, is you try and pre-vet the employee, get positive recitations of what they did in the past, and representations that they have not done anything wrong. If in fact they don't tell you the truth, well, first, you have the defense of good faith, and secondly, if the other side can prove to you that they did something wrong, well, then you have an employee you don't want.
It was very, it was a time where software developers had, USB drives that they took with them wherever they went, and before USB drives, floppy disks. That doesn't exist as much anymore. People are more concerned about, employers are more concerned about liability, and they're asking about it, and employees are more concerned about liability. There's been a few very high-profile cases in algorithmic trading where there's typically the cases are where the money is, and the money is in banking. But there's some sensitivity. So the question is, how do you employ experts? The answer is you do it carefully. You take the steps that Jeff was just talking through. You vet the employee. If the employer is coming directly from a major competitor, you make sure that they don't bring anything with them. You mention to them, they sign a waiver that they're not going to bring anything with them. Those aren't bulletproof. You will frequently, and you do frequently, see cases where the former employer does make a claim. But the best you can do is ensure that that's a baseless claim if, in fact, the employee, hasn't taken anything with them. So it's, again, I'll just repeat it again. I think the answer is you do it carefully by vetting the process. There's a sub-question in there which is more common in Silicon Valley, where you have people on boards of companies and people in investment community who actually also have day jobs in competitive industries. And that's unique to Silicon Valley. It just happens there, and you don't see as much litigation on these issues as you see in say, the New York community in the software and financial software industry.
So I think I'll build on what they both said, and my answer would be schedules. we would, it depends on the type of employee, and if it's a C-level, let's say a technologist, like an idea person who's coming in to kind of, direct the way the company is going to go on a technology basis, and comes from an academic environment that's, so this person has published, has given TED Talks, is involved in various industry groups. That person wants to continue to do that work without those ideas, inuring to the benefit of the company. So that person's really concerned about a couple different things, the work they had done previously and the work that they're going to do going forward. And a lot of this is work made for hire-esque kind of ideas. But, so you really want to schedule, on a practical basis, the way you do things carefully is by writing it down. I'm going to give TED Talks and not talk about, these things, but talk about these things. And really think about, depending who you're, representing. If you're representing the technologist, you're like, okay, what's really important to you? Well, I want to write books on this topic, and I want to write, these types of things. And so that'll be outside of what the company will own. That will be outside of what I have to maintain as company secrets, unless the company goes into that, and then we can kind of talk about it more carefully. But you see that a lot in these new fields where it's very much theoretical. So in some of the fields are kind of small, and I don't want to actually say so. It's just you do, as Mina said, you do it very carefully. You get an employment agreement. At the high level, I think for, at the lower level, so the coders and the programmers who even come from, let's say, a greater open community, really like a very collaborative community. It's about education, and it's about explaining to them that, when you go to a hackathon, you can't incorporate company code into that, or you can't, or let's say internally, you can't use open source code inside our internal code. I mean, that's almost the reverse, which is how do you protect company secrets, which is if you incorporate open code into internal code, you can be giving up the entire open code inadvertently without anyone really realizing it and going to market. So you really want to look at the particular situation and evaluate it.
So on the flip side, as an employee, if you work for a company and you do have an idea that's your own, what do you do to kind of cover yourself in exiting the company?
Move to California. No, I'm sorry, I didn't mean to, but the California has a statute, as you don't know, California has a special statutory 2870, the civil code, that protects ideas that employees have that are their own ideas, not made on the company dime. So that's the reference, move to California.
I think a lot may depend, of course, on what type of employment you were employed to do. I mean, if you were employed at a company to do research, and that was your job, well, one would expect that the intellectual property developed and those fields and the technology belong to the company, and they should not be portable when you walk out the door. On the other hand, if you're working in the machine shop and you're just looking around and you see and you have a terrific idea that could or could not be used in the company, you can keep it to yourself and go into business for yourself. If, on the other hand, you develop it using the tools of the company, the resources of the company, even though it's outside your normal area of work, it harkens back to an old English concept called ShopRite, which would provide that the company would have a limited, non-transferable license to use that technology, even though you weren't, in a sense, hired to invent. But it really comes down to a couple of things, and even with small companies, and this is where we're talking about, you got to kind of paper the house. The cost of trade secrets is in the contracts and in the agreements and in the things you do when you counsel. In terms of one, the company's processes for securing those trade secrets, but also in the contracts and in the understandings they have with their employees and what they say and what the employees agree to specifically in writing. And it seems to me that that is usually the safest. Most companies now that of any size, if somebody leaves, whether voluntarily or not, usually have an exit interview. It is recommended they do it. They sit down and they say, okay, where you going? They don't have to tell you. Often, in fact, they have contractual packages on your severance, which you have, and there's special requirements and statutes relating to some of these, but in essence, you try and define and make clear what the company will consider offensive to it and what their expectations are. You don't have to agree, but at least now you know. And so it sounds very paternalistic, but if you're basically paid to invent and come up with ideas, and that's what you did, and you say, okay, I got the real killer idea, so I'm really not even going to tell my company, but I developed it, and I'm going to walk across the street with it, you'll probably resolve that in the Southern District of New York.
So, you know, I think, you know, if you had a lot of schedules in the beginning, hopefully everything is buttoned up already. Often, a technologist at a company will have an idea, and the company won't want to run with it, and they'll think it's the best thing, and the company owns it. And so that person, I mean, I think it's pretty cut and dry that the company would own it, assuming they did it at their desk at work, right? The way we would deal with that is the employee could seek a license or a transfer of ownership or some sort of agreement on separation to take it and be able to monetize it. We've done that successfully, that, you know, a big provider didn't want to run with some sort of technology, and the employee was able to get a license, an exclusive license to the technology. The company didn't even want any rights to it later on. They just decided they didn't like the idea. He got a license, an exclusive license, or I don't remember, maybe it was transfer ownership, but he basically walked away with the idea and was able to start his own startup based on that. So it's really, you know, that's one way of doing it. The other way of doing it that everyone's gonna, is, you know, scientists often leave without, scientists will switch institutions, and so they'll carry their research from one institution to another. And the way scientists document their work is in notebooks, right? They still have notebooks, and it follows them around. And so various institutions could own different pieces. And when they go to monetize, to our horror, scientists will say, well, you know, if I have a successful idea here, then they'll come after me. And I'm going to figure out how to pitch this and monetize it until then. And that's a horrible way to do things. But that's kind of the reality of what you see out there, rather than going to these different institutions and trying to clear it, which is, you know, insanity in my opinion, but, you know, maybe reflects kind of the reality of the marketplace.
You do have that sometimes in universities in particular, where they have policies, and as we were discussing at lunch, they're not always uniform. Matter of fact, they generally are not uniform, but a lot of universities in particular, and they have research fellows, they have professors, and they have a policy, and it's many of the more enlightened educational institutions have sharing policies. And they also have what they say, if we haven't exploited it, you can take it kind of policy. Commercial companies have sometimes a different slant on it. They have a product that's very successful. You come up with an alternative, and they say they don't want to do it. And you say, well, you've abandoned it. And they say, no, if we do it, it will cannibalize our own business. In other words, we would end up competing with ourselves, and therefore, we want that technology as a fence. We want to own it, but we don't want to exploit it commercially. We want to own it so a competitor won't design around our product. So often a lot of scientists, a lot of people develop products for companies that never see the light of day. The companies patent them if they can, or maintain them as trade secrets if they can, not because they don't want to reward their employees, because they believe that there is a competitive advantage to them of being the only ones with that technology and building a fence around their technology. So in many ways, it's a little bit fact-specific, but so there's really no, how would I say it, bright line answer.
So one more question, and then we'll open it up to Q&A. How has technological advances such as cloud computing affected trade secrets and their protection?
It's become a horror. In the following sense, I think there was a survey, I think I have it here somewhere, and I'll probably, don't want to waste time getting it, and we're running a little bit late on time. I think in 2009, they asked people about, whether you take a disc and this, and how many people have personal devices, et cetera, et cetera. Most companies today have yet to come into the 21st century because they allow their employees to use their personal devices on premises for both business and personal. And as we were talking about with regard to getting an ex-parte seizure, by the time it's on the cloud, it's gone. I mean, you might get very lucky because there's somebody discloses to you that Jeff's about to do that, and you can run to court. But in general now, the speed by which massive amounts of intelligence can be transferred, and the fact that companies who are monitoring all their computers, they can do that. They know who signed on, who signed off, what time. They didn't tell me to check my iPhone at the door. They didn't tell me to check my iPad at the door. I don't mean to just, some people use Samsung, but I mean, I'm not trying to use anybody's trademark. And now what we are seeing and are counseling, and it's something that I'm sure you do it as well. You have to counsel your clients that they have to look again at their policies internally on the ability of their own employees to access data, restore data, download into personal devices. There are, I can't disclose them because we're working on some proprietary technology in this regard, but there clearly is a whole world developing on how to protect companies against this. So the answer is it's becoming more and more difficult, and even with legislation that puts more teeth into it, the speed with which things disappear, go out into that ether, and whether it be Korea, China, Germany, wherever the case has brought us to these things, they don't have to stand on the tarmac in JFK and get ready to get on a plane. They're getting on a plane to collect a reward. They can go with their hands, with their passport and nothing in their pocket. That stuff's been up, out, and gone. They don't even have it on their person. So it is a challenge for us as attorneys to understand the technology, understand the possibilities. You can write all the agreements you want, basically, and even for entrepreneurs, to look at this in the new world as maybe even an opportunity, because security is now on almost everybody's mind, and it's legitimate. Companies are really concerned, and they're frankly putting a lot of effort into trying to figure it out. I'm not that smart. I learned it from companies that have recognized that issue.
Yeah, it's a very interesting question. How has it impacted or affected trade secrets? It really hasn't impacted trade secrets. What's impacted is what we've heard so many times today. It's impacted the dissemination of trade secrets, and obviously it's made breaches that would take a long time to have a material impact almost simultaneously. So, I mean, I think, and my practice is mostly in the tech space, software space. I think it's great. I think the cloud and the offers that the technology provides, advances that we have in technology are phenomenal. It's I was just in San Francisco with Adobe, working with them on a matter. They moved Photoshop entirely to a cloud-based platform. This is, if you grew up at all in photo imaging, this was like the Bible of photo imaging. You got 10 CDs or 100 floppy disks that you installed one after another, and you needed gigabytes of RAM. And now this is a product that's almost exclusively based in the cloud. Microsoft Word and Google Docs and all these other things. So there's great technology advances for society and for mankind, and they're phenomenal. The question is, how do these technologies impact what we've done and how we've taken care, addressed some of our concerns around trade secrets in the past. And I think that's shifting, and I think that law and legislation typically lag behind advances in technology. We had an earlier panel talking about how legislation may catch up a little bit, but that's a cat and mouse game that's existed and will continue to exist. So I think that over time we'll see changes in legislation. We'll see, given that, and as we all heard, trade secrets are, at least today, state law, in the state law review, so we'll see changes in courts and how they address these things slowly, very slowly, but I think the jury's out on how it will impact trade secrets going forward.
Well, I think it's been a boon to forensic investigators. It's kind of, they are, even with cloud technologies, they're able to go to an employee's desktop and figure out what they've been doing. It takes time, but they can recreate it. I think employers should be taking steps to disable Dropbox and various other social media sites, or bifurcate the server, so if they're actually in, let's say, Gmail, they're not able to transfer from the system into Gmail. So they can use separate servers and they can protect this. That doesn't go to the bring your own device kind of concern, which is, I have my firm email and my personal email on here, and how do I separate them? Well, when I first clicked I agree, I actually read it because I read those things. It says on there the firm has the right to wipe out my whole device and to monitor my communications. I don't know if anybody actually does. I know that other people have installed different programs because they didn't like that concept when I told them we had just rolled out this new package. And so you're actually able to install, and the firm should fix it, but you're able to install your own internet client or Outlook client to connect with your email. So for bring your own device, and just the camera functionality is a nightmare anywhere, right? I mean, the camera is probably one of the biggest leakers of information potentially, and any place you go, like a courthouse, they make you put the cameras away. In the firm or in a company environment, I think IT has to take the lead here and really put the clamp on different technologies that allow it, and take protective action to protect trade secret leakage, and then encourage the use of that in a non-threatening way, rather than saying it's totally off limits, you can do it like this.
And I can tell you as a dinosaur that when the IT people come to the management meetings and explain it, and our eyes glaze over, and they get frustrated, that there is an educational level too, because frankly, senior management in most larger entities did not grow up in this technology world, do not speak the shorthand, nor are sophisticated enough how my grandson can circumvent anything I do in 5 minutes and laugh. So I think it is a challenge, and it's going to be a challenge going forward. And frankly, as a litigator, I think it's going to end up being somewhat of a Fair Employment Act, because I think there's just going to be a lot of issues that come out of this that the courts are going to have to address, many of which themselves look very heavily on their clerks. I know some of the federal judges who look very heavily on their clerks because they themselves are catching up with the language of the technology, so that they understand the facts of the case before them.
And actually, add to that a couple points that, a company should be looking at security systems like SAN 20. If you're in a banking field where you're a vendor to a bank, banks are now considered critical infrastructure, and so they have to go through, or will be forced to go through very soon, different auditing procedures, and SAN 20 is one of these, and it gives you 20 different things to think about in how to secure your business, and so that's a very practical roadmap to securing, because what we've really been focusing on is like the insider threat, what happens from an employee. As much of it a threat is, if you're an energy company, it's China coming in and hacking your system, right? Or, Ukraine or Russia or somebody coming in and a hacker there trying to monetize credit cards or whatever it is. And so firewalls and just actual security around your environment to protect it is huge, and really something that I think we hear about breach after breach after breach, and all these leaked passwords and credit cards, and the damage there is you know, in the billions of dollars and reputational, and you really don't, sometimes you don't come back from it, but, you know, a lot of companies do. You know, we all still shop at Target, right? But their revenue is down for, you know, for a while, and I think, and, you know, JP Morgan, the same thing. So I think that you have to look at not only the insider threat, but also the industry you're in and how you're protecting your infrastructure from a breach. And the reality is that every company out there, there's constant attempts at breaches. And so they really need to be, you know, IT should be saying, okay, we've had this many attempts and this is how we're stopping them, you know, and figuring out ways to lock it down.
Do we have time for questions? Yeah, like, does anyone have a question from the audience? Well,
It's amazing what 5 o'clock will do to people.
You just had such great questions. They've all been asked.
so Professor Beecham will have a few closing remarks.
Well, since we're at a lower time, I'm just going to say two very quick things. One is about the TSI's current and future programming. So if you haven't had a chance to check out the websites or our Twitter feed, I urge you to do so. There's some interesting stuff that goes up there. And also if you're someone who might contribute content, so we're interested in publishing commentary by practitioners, by students. We're very interested in publicizing academic work. If you've written something and you want links to it or a mention of it or some discussion of it, that's all stuff we can do. Likewise, if you practice in this area, or if you know someone who practices in this area, and you come across interesting issues, interesting cases bubbling up at an early stage, we can follow them, we can try and contextualize them for people who are interested in this field. That's all stuff that we love to do. So please feel free to get in touch with me or any of the fellows, or email tsi@brooklaw.edu. And if you're a student, there are lots of other ways to get involved as well, so come and see me about that. So that's one thing I want to do. The second is just to thank all the people who've been involved in making this such a great event. The law school staff, Liz Alper, the events and IT staff have done a wonderful job in making everything run smoothly. Our students who have helped out. The speakers have been just fantastic. I'm really just amazed that we managed to get so much expertise for so many questions for so long. Their time is all very valuable, so that's been great. And then finally, our 3 TSI fellows have just done a lot to shape the intellectual agenda and the event itself. I'm just enormously grateful. So please join me in thanking the panel and everyone else. And that's it.